Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 5422 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5422, to ensure funding for the National Human Trafficking Hotline and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Today we consider H.R. 5422, a bill to ensure funding for the National Human Trafficking Hotline and for other purposes. This bill corrects an inadvertent change made in the Justice for Victims of Trafficking Act of 2015 that caused grant funding for the National Human Trafficking Hotline to be processed through the Department of Justice rather than through the Department of Health and Human Services, as it had been historically. The National Human Trafficking Resource Center is a toll-free hotline available to answer calls from anywhere in the United States 24 hours a day, 7 days a week, in more than 200 languages. The hotline's mission is to connect trafficking victims and survivors to critical support services and to equip the anti-trafficking community with the tools to effectively combat all forms of human trafficking. This bill was introduced on June 9, 2016 by Congressman Ted Poe, who has been a tireless advocate for the prevention of human trafficking and for trafficking victims. This morning we're keeping Congressman Poe in our prayers as he undergoes treatment for leukemia. He's a tremendous asset to this committee, and I'm confident that his tenacious spirit will help him through a quick recovery. I thank Congressman Poe for sponsoring this legislation that corrects an inadvertent oversight, and I urge my colleagues to support the bill. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte and members of the committee. H.R. 5422 is a bipartisan measure intended to ensure funding for the National Human Trafficking Hotline. This common sense bill would direct funding to the Department of Health and Human Services to administer the grant money for this hotline. The crime of human trafficking is, of course, a terrible scourge that deprives people of their dignity, humanity, and freedom. Men, women, even children are held here against their will. They are often repeatedly beaten, starved, drugged, and forced to perform unspeakable acts under the threat of more brutality against themselves or to their loved ones. Unfortunately, this awful crime continues to grow and spread because many victims are unable or afraid to leave those who hold them captive. Those who are able to escape their captors often fear retribution if they cooperate with law enforcement. One mechanism Congress established to help victims of trafficking is the 24-hour national hotline operated by the National Human Trafficking Resource Center. The hotline provides critical care and attends the needs of victims and survivors of human trafficking in the United States, its territories, and in more than 200 different languages. The Resource Center connects victims to services they need immediately and other legal advice and safe havens, and to services that can help them recover, including counselors and medical providers. The center not only handles calls for potential trafficking victims, but also from law enforcement officers and officials, medical and legal professionals, legislators, and community members seeking to combat human trafficking. In 2015, the center responded to more than 5,500 cases of human trafficking and received about 1,500 online reports of suspected human trafficking. H.R. 5422 simply corrects an error created by an inadvertent change in the funding source for the hotline made by the Justice for Victims Act of 2015, which mistakenly directed funding from the hotline to the Justice Department instead of the Department of Health and Human Services, which is the agency actually responsible for funding the hotline. I fully support H.R. 5422 and commend my colleagues, the already mentioned gentleman from Texas, Mr. Poe, as well as the gentlelady from Texas too, Miss Jackson Lee, Sheila Jackson Lee, for their diligent work on this bill and other efforts to combat human trafficking. I commend them both. As we look forward to the next Congress, it is my hope, Mr. Chairman, that we will continue to find common ground on issues of mutual concern and work together to enact bipartisan bills such as this one. And so accordingly, I urge adoption of this bill today, and I yield back the balance of my time. Thank you.
Thank you, Mr. Conyers, and without objection, all other opening statements will be made a part of the record. Are there any amendments to H.R. 5422? For what purpose, the gentlewoman from California seek recognition?
Mr. Chair, I move to
Been
strike
away
the
for a
last.
little while.
Move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Thank you. Mr. Chair, I also join with you in extending our best wishes and prayers to Judge Poe and commend his leadership on this issue. I was very happy to see this bill that will correct and move the funding from the Department of Justice to HHS. This committee has worked on the issue of human trafficking and understands that it is a crime where victims can be found in districts and around the globe. Programs like the National Human Trafficking Hotline are designed to assist in identifying, preventing, and rescuing girls, boys, women, and men who've been trafficked. A particular focus that I have worked on with other members of this committee is the trafficking of children, and especially those children who are involved in the foster care system. In Los Angeles, several years ago, 59% of the children arrested on prostitution-related charges were in the foster care system. Fortunately, in Los Angeles, as in many other cities, we are beginning to look at the issue differently now, and children are not arrested anymore. Children who are found to be trafficked are actually triaged into services. And our country in general is becoming far more enlightened about how to address this issue. One of the things that we're also beginning to do in the Los Angeles area is to involve the community, in particular the faith community, in identifying underage children that are trafficked and teaching pastors and other faith leaders how to identify trafficking victims. And the hotline is one of the things that we direct them to in terms of a concrete activity where they can get involved in helping in the rescue of children. One of the issues that I hope that this committee addresses in the future in regard to trafficking is shelter, because we know that one of the main reasons why, whether it's a child or an adult, goes back to the trafficker is because they don't have any place to go. So I'm hoping that in the future we will begin to tackle that issue. The other thing about reverting the funding back to HHS, I'm hoping that it will allow for the better coordination and actually increasing of resources, because it is possible that the hotline funding can be aligned with other programs that address at-risk populations, including children. And I yield back the balance of my time. Thank you.
Chair thanks the gentlewoman. Are there any amendments to H.R. 5422? All right, given the lack of a reporting quorum, further proceedings on H.R. 5422 will be postponed. Pursuant to notice, I now call up H.R. 1669 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1669, to amend Title 31 United States Code to provide for transparency for payments made from the Judgment Fund.
Without objection, the bill is considered as read and open for amendment at any time. I will begin by recognizing myself for an opening statement. The Judgment Fund was originally set up to provide a mechanism for the federal government to pay damages to parties in a timely manner who have been harmed by the federal government. The purpose of the Judgment Fund is thus a good one, but the administration of it must be more transparent. H.R. 1669, the Judgment Fund Transparency Act, is as much about disclosure to the public of information about government activities as it is about oversight. Indeed, given the requirements set out by the Judgment Fund statute and in light of recent cases, it's clear that greater oversight is needed with regard to government litigation and resulting payments made by the government. In this respect, H.R. 1669 is intended to protect the institutional integrity of this body as it relates to the power of the purse. James Madison, in Federalist Number 58, stated, "The House of Representatives cannot only refuse, but they alone can propose the supplies requisite for the support of government. They, in a word, hold the purse, that powerful instrument by which we behold in the history of the British Constitution an infant and humble representation of the people, gradually enlarging the sphere of its activity and importance, and finally reducing, as far as it seems to have wished, all the overgrown prerogatives of the other branches of the government. Under the current Judgment Fund statute, a final judgment or settlement against the government will be paid out of the Judgment Fund as long as 3 conditions are met. First, payment must not be otherwise provided for. Second, the Secretary of the Treasury must certify payment. And third, the judgment must be payable according to one of several specified statutory provisions. These provisions provide a finite set of circumstances in which the Judgment Fund may be used. However, reports about recent payments from the Judgment Fund have questioned whether the fund is being used appropriately. In order for Congress to properly do its job of exercising oversight over the Judgment Fund, we need to have more information about the payments being made from the fund. For these reasons, I strongly support this bill. And at this time, I'm pleased to recognize the ranking member of the committee, the gentleman from Michigan, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, while the purpose of H.R. 1669, the Judgment Fund Transparency Act, is ostensibly to promote greater transparency in government, I fear that its real purpose may be, once again, to attack the Obama administration's integrity. The bill would require the Treasury Department to publicly disclose via the internet various details about payments it makes on claims paid out of the Judgment Fund, most of which is already available on the department's website. I question the impetus for the bill, which seems to be assertions by some that the Obama administration's payment of money to Iran to settle longstanding pre-revolutionary legal claims was somehow illegitimate. If that is the case, I reject such a premise and hope that most of the committee will do as well. To begin with, no one can dispute that the administration's use of the Judgment Fund to settle Iranian claims against the United States earlier this year was perfectly legal. The State Department negotiated a $1.7 billion deal to settle claims between the United States and pre-revolutionary Iran, which included $1.3 billion in interests paid out of the Judgment Fund. In 1989, Justice Department opinion makes clear that the State Department may seek payment from the Judgment Fund to pay claims or settlements stemming from matters before the U.S.-Iran Claims Tribunal, as was the case here. Indeed, Professor Paul Figley, the witness of the majority, acknowledged that, and I quote, the Obama administration had the authority under the Judgment Fund statute to pay and settle the Iranian claim with interest, in quotations. In addition to being perfectly legal, the Obama administration's actions actually saved American taxpayers billions of dollars. I know that $1.3 billion sounds like a large sum for interest payments, and it is. But the United States, however, could have owed Iran billions more for over 30 years' worth of interest on the principal owed to Iran if we had not settled those claims when we did. The Iran payments demonstrate that the Obama administration acted prudentially to protect American taxpayers. And finally, contrary to what some critics claim, the administration has been fully transparent. The Iran payments were disclosed to the public at the time that they were made. The Obama administration announced the Iran payments when they were made in January of 2016. And there's no doubt that the administration made no effort to hide them. And so there's no support for any characterization of these payments as ransom. While the Obama administration has acknowledged that it withheld payments to ensure that Iranians followed through on the release of 4 of our own American prisoners, these negotiations were carried out by separate teams and were unrelated. In short, the Obama administration's actions regarding the Iran payments by themselves do not justify additional scrutiny of the Judgment Fund. I thank the chair and yield back the balance of my time.
The chair thanks the gentleman. Without objection, I would like to submit for the record statements by Representative Chris Stewart, the chief sponsor of this legislation, and by Senator James Langford. Without objection, they will be made a part of the record. Are there any amendments to H.R. 1669? For what purpose does the gentleman from Arizona seek recognition?
Mr. Chairman, I have a statement.
I think you have a substitute.
Okay. May I make a statement before I do the substitute?
Yes, you may make a statement. Gentleman's recognized for 5 minutes.
Yes, sir. Mr. Chairman, the Constitution states that, quote, no money shall be drawn from the Treasury but in consequence of appropriations made by law. This power over the purse, James Madison stated in Federal Paper number 58, quote, may in fact be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people for obtaining a redress of every grievance and for carrying into effect every just and salutary measure. It's clear that our nation's founding generation understood that establishing popular control over government finance would provide an essential check on the executive branch. The tyrannical assertion by the authority, by the British Crown, as detailed in our Declaration of Independence, no doubt fostered distrust of unelected officials who were not directly accountable to the people. Nevertheless, Congress has over time delegated its fiscal responsibilities to the executive branch, particularly with regard to the payment of litigation awards against the United States. In 1956, Congress enacted the Federal Judgment Fund to pay final judgments, quote, not otherwise provided for by another source of funds. Over time, Congress has modified the judgment statute to, for example, allow for the payment of compromise settlements of actual or imminent litigation entered into by the Attorney General. Congress has also removed that cap that had restricted the judgment fund's availability to a certain threshold amount. Today, the judgment fund is described as a, quote, permanent, indefinite appropriation that requires no congressional action to make payments of any amount for certain claims against the United States. Certification by the Treasury Department is one of the final administrative steps before the judgment fund is available. This process is performed by the Department's Financial Management Service. While not reviewing the merits of the underlying claim in its certification process, it performs the important task, among others, of confirming that the claim is not, quote, otherwise provided for by another source of funds. In sum, the Treasury Department determines whether the statutory conditions for payment have been met, including the judgment fund's legal availability. As the judgment fund's gatekeeper, the Treasury Department also maintains information provided by agencies seeking payment. While the U.S. Treasury Department provides an online database, quote, for the purpose of tracking the status of approved judgment fund payments, it is difficult to search, fields are incomplete, and it provides little information useful to the general public. For example, the names of plaintiffs are not used. The names of plaintiffs' counsel are also not listed. Without such information, there's little context provided for the listed payment amounts. H.R. 1669, the Judgment Fund Transparency Act, introduced by Congressman Chris Stewart, is a common-sense bill intended to make publicly available certain information regarding claims paid for the judgment fund. It codifies and improves the service that the Treasury Department is providing. And I would ask all members to support this important bill, Mr. Chairman. And finally, I would offer an amendment in the nature of a substitute that will require additional information be made publicly available for payments to foreign states. And I plan to have a more detailed description of this amendment once it's offered. And thank you, Mr. Chairman.
What purpose the gentleman from Tennessee seek recognition?
To make an opening statement.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. When this bill came before us, there was concern on my part and others that this was a failed attempt to question the Iran agreement and the administration. And while I'm in favor of transparency and continue to be and will always be, I had some problems with it at the time for that reason. Of course, a lot of things have changed. And I hope that as things have changed, that those who were prominent in talking about and having a special subcommittee on oversight of excessive government regulations and oversight of the executive will still have that concern about legislative prerogatives and about Article 1. I think this committee has the potential to be very bipartisan in standing up for Article 1, which is an article that I'm not sure is known on 5th Avenue and 56th Street. I don't think they know what Article 1 is. And Article 1 is us. And we're going to have, as the Judiciary Committee, an important role in making sure that the executive doesn't run over the legislative branch, the judicial branch, and every other branch. So it'll be interesting in the next 4 years to see how much we do that. I hope my colleagues will join me in having great oversight over the executive. I'm in favor of transparency. This is transparent. We must need as much transparency as we can get with this new administration that seems to have very little concern about transparency and very little concern about tradition. And the Constitution is something that's a tradition. It's more than a tradition. It's what we swear an oath to uphold. And Article 1 is the first article. So I look forward to all the people who have brought bills, and we've had hearings on the importance of oversight, on the importance of this committee standing up for legislative authority, knowing that this is the body that the people's house, most direct election. So I'll favor this bill. It's much similar to a bill that I have where I was the lead Democratic sponsor on the Open Book on Equal Access to Justice Act, which I think Ms. Lummis and I sponsored and which passed, and was a good bill, a good compromise. And so I thank the chairman, and I look forward to working on this committee as a strong check for the American public on what could be a very unusual 4 years. I yield back the balance of my time.
The chair thanks the gentleman, and I now recognize the gentleman from Arizona for purposes of offering an amendment in the nature of substitute.
Well, thank you, Mr. Chairman. Mr. Chairman, in early September, the Subcommittee on the Constitution and Civil
If the
Justice...
gentleman would suspend, the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1669 offered by Mr. Franks. Strike all that follows after the enacting clause.
Without objection, the amendment will be considered as read, and I now recognize Mr. Franks to explain the amendment.
All right, thank you, Mr. Chairman. Mr. Chairman, in early September, the Subcommittee on the Constitution and Civil Justice heard a hearing titled Oversight of the Judgment Fund, Iran, Big Settlements, and the Lack of Transparency. At the hearing, witnesses expressed support for H.R. 1669, the, quote, Judgment Fund Transparency Act, a bill that would statutorily require information making public payments about the Judgment Fund. Professor Figley, for example, stated, quote, maintaining the fog around the Judgment Fund payments undercuts the transparency that makes for better government. No strong governmental interest supports keeping Judgment Fund information secret. Routine publication of Judgment Fund payments would bring the disinfecting sunlight of disclosure and would discourage payments made for illegitimate or irrelevant reasons. Professor Kinkoff of the Democrat invited witnesses at the hearing stated in his written testimony the information that H.R. 1669 would, quote, require the executive to disclose would allow the public and Congress to monitor the use of the Judgment Fund and to have some basis for identifying instances of overreach, unquote. He further stated that the bill was a modest measure that respects the constitutional separation of powers while allowing Congress to fulfill its constitutional responsibilities. My amendment to H.R. 1669 is very much in line with the underlying purpose of the bill, which is increased transparency and accountability with regard to the final judgment and settlements paid by the Judgment Fund. Indeed, this amendment ensures that the Treasury Department continues to make public data that includes but is not limited to the following data fields: the docket number, the court jurisdiction, the payment ID number, and the date the payment was sent. It also includes information about the payment amounts, including the principal amount, attorney's fees, and the cost and interest amount. Further, this amendment would require that additional information be made public if the funds are being paid to a foreign state, including the method of payment, the currency used, and the name and location of financial institutions the payment is routed through to reach the foreign state. And finally, Mr. Chairman, this amendment makes it clear that the disclosure of information required in this bill is not considered a violation of Title V of the United States Code except with regard to children under the age of 18. This particular provision is in direct response to Professor Figley's testimony in which he stated that the Treasury Department refused to release the names of claimants or individual attorneys in Freedom of Information Act requests, claiming that such information violated Title V. As Professor Figley points out for the purposes of comparison, that a, quote, matter of policy, the Department of Justice will not agree to settlements or consent decrees that contain confidentiality provisions, unquote. Moreover, I agree with his statement that there is, quote, little reason to keep successful claimants from being identified as successful claimants. And with that, Mr. Chairman, I would just urge all members to support this amendment, which improves on this much-needed transparency bill.
Mr. Chairman,
For purpose, the gentleman from Michigan seek recognition.
I rise with some concerns about the substitute amendment.
Gentleman is recognized for 5 minutes.
Thank you very much. Members of the committee, to begin with, it contains in this substitute a broadly worded provision that may erode personal privacy protections. Let me explain. Specifically, this provision would deem the disclosure of information required by the legislation as not being a clearly unwarranted invasion of personal privacy for the purposes of Title V of the United States Code. This broad reference to Title V could be construed to sweep away personal privacy protections under the Privacy Act and the Freedom of Information Act, and maybe even some other statutes. Any legislation that obliges the government to publish information, and especially private information, about individuals without their explicit consent should give every single member of this committee some excuse to pause and rethink where we're going with this substitute amendment. I acknowledge that a person's name or the facts of his or her lawsuit, which may contain personally identifying information, is in many instances a matter of public record. There may be cases, however, where there is a privacy, a strong public interest in maintaining privacy protections. Whistleblowers, for instance, may be dissuaded from filing suit against the government for misconduct if they fear retaliation after being identified in a disclosure under this bill. At a minimum, we should think carefully about the full ramification of what seems on its face, at least, to be a broad exemption to existing privacy protections. And in addition, I'm concerned that the substitute amendment may make it impossible for the Treasury Department to comply with its requirements. Under the amendment, the Treasury Department must publish information for any payment from the judgment fund within 30 days of such payment, including claims paid from January 1, 2016 onward. The problem, of course, is that for many claims paid since January 1 of this year, we are now well past the 30-day disclosure deadline. Even if the bill were to become law tomorrow, the Treasury Department...
Committee needs to be in order. The gentleman deserves our attention. Recognized.
Even if this bill were to become law tomorrow, the Treasury Department would already be out of compliance with its disclosure requirements for every judgment fund payment made prior to October 19, 2016. Also, it's far from clear that the bill's 60-day delayed effective date would give the Treasury Department sufficient opportunity to comply. This effective date provision, after all, does not specifically reference the retroactively applied 30-day reporting deadline. Finally, I question why we're proceeding so quickly with this bill, particularly given the lack of process. Had we more time to properly vet this substitute amendment, the text of which we only received last Thursday evening, perhaps some of the concerns I raised could have been addressed. And we have had no legislative hearings on the underlying bill itself, let alone the substitute amendment. And so I plead with every member of this committee and hope that we can work together to address these concerns before this bill moves further in the legislative process. I thank the chairman and I yield back.
Are there any amendments
Chairman.
to the amendment?
Mr. Chairman, may I ask unanimous consent to include the letter from the Professor Kinkoff, the professor of law?
Without objection, the letter will be made a part of the record.
Thank you.
Are there any amendments to the amendment in the nature of substitute? For purposes, the gentleman from Iowa seek recognition.
Mr. Chairman, I have an amendment at the desk, numbered 360.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1669, offered by Mr. King of Iowa. Page 1, line 9.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment just simply goes into the substitute amendment of Mr. Franks and effectively strikes the word or court order. And I bring this up because of my concern that we will have judges that simply use what they would call discretion to block information that would otherwise need to be available to this Congress and perhaps to the public. And so the final component of this amendment says no court may issue an order prohibiting the disclosure of information under this subsection unless specifically authorized by statute to issue such order. And I think it's part of the full disclosure piece of this. And for me, I've had great frustration in trying to get into this judgment fund and understand the dollars that are there, where they come from, where they sit, where they go, why this legislation is in front of us. And if we end up with a dark hole that could be created by activist judges, then I think that it's a potential gap that we would regret if we don't address this today. And so that's what I do, is just simply prohibit the court from having the discretion to block this information from the public. I'd urge its adoption, and I would yield back the balance of my time.
Chairman,
For purposes, the gentleman from Texas seek recognition.
to strike the last word.
Gentleman is recognized for 5
Unanimous
minutes.
consent. Let me join with the ranking member, Mr. Conyers, on some initial concerns, but I want to express the importance of the underlying bill. And I want to share with my good friend from Iowa, and those of us who've come back have the privilege of serving in the next Congress. We are good friends. We've been on this committee for a period of time. I hold very dear the concept of three branches of government, the legislature, the executive, and of course the judiciary. We have some forms of oversight, the three branches, meaning the Congress, Senate, and House, in their respective responsibilities, have influence or oversight. I don't want to use the word influence, oversight, in some respective ways over our courts, over the executive, and certainly we represent the American people. I am concerned about the amendment. I'm trying to discern what impact it would have on an independent judiciary. What comes to mind is the potential of the judiciary having facts and petitioners before them, whether it's the governmental agencies, making a point that should be respected, and that they, in their non-activist posture, but in the adherence to court precedent that may not be statutory, make a decision on the disclosure of information. That would be up to Congress to counter that in whatever appropriate way that they would do it. Normally, it would be possibly in its own action or legislative action. So I'm concerned about an amendment that specifically tells a court and judges all courts of being activists, because I don't view courts as being activists, because they can be activists in different ways, and I can see activism one way and they can see another activism in another way. We hold them as an independent judiciary that can make decisions based on fact, law, precedent, etc. So I would ask the gentleman, why are we having an amendment that is attempting to put these kinds of constraints on an independent judiciary? That is not something that I believe is appropriate, and as it is explained, I would have to oppose this amendment. Unless the gentleman, Mr. King, has any clarifying response. He's indicating that his tears are coming out of his eyes, I assume, but I know that the opposition in our numbers will not prevail, but I hope the record reflects that this is an amendment that brings about a lot of challenges, and I would be of great concern as to the appropriateness of this amendment. And I think it does disservice to the underlying bill. With that, I yield back.
Question occurs on the amendment offered by, for purpose, the gentleman from Michigan seek recognition.
Mr. Chairman, I'd like to make a statement.
Gentleman is
about
recognized
this
for 5
amendment.
minutes.
First of all, I want to commend the gentlelady from Texas for her keen analysis of some of the problems involved. And I would like to make it clear the reason that I have some reluctance that grows the more I study this amendment. This amendment would further erode privacy protections under this bill, a concern I'm already worried about, by reducing the discretion of the courts. The legislative body, this distinguished committee, is reducing effectively the discretion of the courts to protect sensitive personal information, potentially including that of minor persons, minor persons. Now, I hope that this rush to move this forward with so little critical examination, this is a provision I'd never contemplated before, but I would hope that the majority of this committee would join those of us who are opposed to the bill, but much more importantly at this current moment, opposed to this amendment itself. I would urge that you join us in opposing the amendment. And I thank the chairman for allowing me to get this discussion moved forward in our decision-making process. I yield back the balance of my time.
The chair thanks, gentlemen. The chair recognizes himself on the amendment and would say to the gentleman from Iowa that I understand and fully support the intent that the gentleman has in this language, but the chair also shares some of the concerns just identified by the ranking member about certain types of information that if there's not some kind of discretion left to the court with regard to a settlement involving sexual abuse of a minor by a government employee that's paid out of a judgment fund, or who knows what types of judgments might require some discretion on the part of the court before the information is simply made publicly available to the Congress. There might be ways to do it where the Congress gets the information but it's not made public. There might be ways to do it where the court is allowed discretion in certain limited ways, but not discretion like the underlying bill seems to allow. What I would suggest to the gentleman, if he's willing to do so, is that he withdraw the amendment and work with us as we move to the floor to perhaps fine-tune this amendment and accomplish the goal that he has without raising the objections that you've just heard.
If the gentleman would yield.
I'd be happy to yield to the gentleman.
I thank the chairman for his judicious review of this, and I think we are working a little bit on, from my standpoint, on a bit of a hurry up and haven't had the opportunity to look at all of the ramifications. In fact, the chairman says himself, who knows what might be in these judgment settlements, because that's why the legislation is before us. We don't know. So I'm hopeful that we can give it a real good look and take a look at the national security concerns that my friend Trent Franks has also put into my ear. And with that in mind, and with preparations of potentially going to the floor, if we could have those discussions under those conditions, I'd be willing to ask unanimous consent to withdraw this amendment and take a look at it if we go to the floor with this bill.
Without objection, the amendment is withdrawn. The chair thanks the gentleman, and we'll definitely work with him on his concerns.
Thank you, Mr. Chairman.
And I understand the gentleman has another amendment.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment. For purposes of the gentleman from Ohio, seek recognition. Gentleman reserves the point of order, and the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1669 offered by Mr. King of Iowa. Add at the end of the bill the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This is a long-standing endeavor on my part, having long looked into the judgment fund and the distribution of those funds and come up empty almost every time because we have had an intransigent administration that just refused to cooperate. And I think everybody on this committee has watched witnesses come before this committee and either run out the clock or refuse to answer questions or even take the fifth. So to get to the bottom of the billions of dollars that have been distributed under the judgment fund, this underlying bill, the underlying substitute amendment of Mr. Franks is prospective. In that it produces a look into it, but not a deep enough look. And so this amendment calls for a GAO audit, an audit, and that not later than 1 year after the day of the enactment of this act, we'd actually have an audit by the Comptroller General of the United States, and to audit the payment and the amounts, and that report would go to the Judiciary, the Oversight, and the Appropriation Committee in both the House and the Senate. And that's part of what I believe is the object of this underlying bill, is to put sunlight on the judgment fund, and also to take out of the hands of the executive branch the ability to transfer funds, whether or not it's their political favorites, that this Congress needs to be appropriating the money. We've got to know where it goes before we can make those decisions, and we should not leave it up to the judgment of the people that are now managing the judgment fund. And I would go further, Mr. Chairman, and suggest that we need to do a GAO study that's looks backwards, not only the prospective, the audit going forward, but the retrospective audit going backwards. We should know over, say, the last 10 years what has gone into the judgment fund, where it's been distributed, and what is left in that judgment fund. And so I call for this audit going forward. I don't know that that is even enough to get us the sunlight on this that we need, but I would urge the adoption of this amendment for the GAO audit. The annual audit is simply what the amendment does, and urge its adoption and yield back the balance
Would the
of my
gentleman
time.
yield?
Yes, it would.
I thank the gentleman for yielding, and again, I appreciate the gentleman's objective. I think that the problem we have here is that this amendment is beyond the scope of the bill, and as you know, there will be a motion made to disallow the amendment as non-germane. However, I think there may be a way to accomplish this that does satisfy the gentleman's concerns, and again, if the gentleman would be willing to withdraw this amendment, we would be happy to work with him on finding a way to accomplish his objective that still is within the scope of this bill.
Well, in reclaiming my time and recognizing that the ability to request an appropriate GAO study exists within the purview of the chair and the committee, and understanding and openness to that request for not only a prospective but a retrospective audit request and an opportunity to work on this as we go to the floor, I would thank the chairman for his indulgence, and I would ask unanimous consent then to withdraw my amendment.
The chair thanks the gentleman, and the chair will work closely with him on both these ideas so we can address his concerns, and without objection, the amendment is withdrawn. Are there further amendments to the amendment in the nature of substitute? The question is on the amendment in the nature of a substitute. All those in favor respond by saying aye. Those opposed, no.
No.
In the chair, the ayes have it, and the amendment is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 1669 as amended favorably to the House. Those in favor respond by saying aye. Those opposed, no.
No.
The ayes have it, and the bill as amended is ordered reported favorably. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We'll now return to reporting H.R. 5422, A reporting quorum being present, the question is on the motion to report the bill H.R. 5422 favorably to the House. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. This completes our business for the day. I thank all the members for their participation and for their expeditious consideration of these bills, and the markup is adjourned.
Notice your